Chapter 9, Industrial Actions, Part 2. The learning outcomes. At the end of this topic, students will be able to define strike and lockouts, discuss the procedures for strike and lockouts, explain procedures for strike, lockouts in essential services. Definition of strike. Under Section 2 of Industrial Relations Act, any stopping of work by a group of workers, including any attempt to limit or slow down production on purpose. Members of a registered trade union have the right to strike in the event of a trade dispute. For a strike to be legal, it must comply with the requirements laid down in the Industrial Relations Act and Trade Union Act. Strikes not only need the workers to stop working, it can also take place when a reduction of output occurs, such as slow down, work slow, work to rule. Lockouts. Employers are also vested with the rights to execute a lockout in furtherance of a trade dispute, which means the closing of a place of employment, the suspension of work, the refusal by an employer to continue to employ any number of workmen employed by him. A lockout is a form of self-help by employers to persuade workers to accept management proposals. A lockout can be declared by either an individual employer or by a trade union of employers. Lawful strike or lockouts. Strike or lockouts is only legal if they comply with the regulations in Industrial Relations Act and Trade Union Act. There are three legal requirements of strike or lockouts. First, must belong to a registered trade union. Second, must be in furtherance of trade dispute. Third, must carry out a secret ballot by those eligible to strike. Okay, strike procedures. Under Section 25A bracket 1, 40 bracket 2, 40 bracket 3 of Trade Union Act, prior to strike action, the workers concerned must hold a secret ballot, only valid for 90 days after the date on which the ballot is taken, determine whether at least 2/3 of the workers agree to strike, send the ballot papers to DJTU within 14 days, undergo a 7 days cooling off period before commencing the strike. Workers in essential services must wait 21 days before commencing a strike. When strike is not permitted. Under Section 44 of Industrial Relations Act, strikes are not permitted over a collective agreement that has been taken cognizance by the Industrial Court, over the management prerogatives, Section 13 bracket 3, during the proceedings of a board of inquiry, and 7 days after conclusion of such proceedings, once the dispute has been referred to the Industrial Court. In the case of public sector employees, after YDPA or state authority has agreed to the reference of trade dispute to the Industrial Court. Strike, lockouts in essential services. Workers in any essential services, first schedule of Industrial Relations Act, who wish to go on strike are required to serve a notice of strike to their employer. No workman in any essential service shall go on strike without giving to the employer notice of strike within 42 days before striking, within 21 days of giving such a notice, or before the expiry of the date of strike specified in any such notice aforesaid. Strike or lockouts in essential services. No employer carrying out on any essentials No employer carrying on any essential service shall lock out any of his workmen without giving him notice of lockout within 42 days before locking out, within 21 days of giving such notice, or before the expiry of the date of lockout specified in any such notice as aforesaid. Topic summary. Strike is a refusal to work organized by a body of employees as a form to protest, typically in an attempt to gain a concession or concessions from their employer. A lockout is a form of self-help by employers to persuade workers to accept management proposals. The employees or employers are required to follow proper procedures in conducting strike or lockouts, as it will lead to several legal implications and penalties.